Good afternoon, everyone. Thank you for joining us today and watching this video. I am Diana Murray with ASAP Accounting and Payroll, and I am happy to present a quick video on some of the upcoming changes as it relates to employment law. Definitely looking back on regulations that passed even in 2019 and 2020, but looking ahead to 2021 and what's coming down for employers to be in compliance with. I'm really excited to be joined with Michael Santo of Bechtel, Santo & Severn as our employment law attorney and guest speaker for today. And he will be touching on these topics very specifically. So without further ado, I'm going to turn it over to you, Michael. Thanks so much.
Thanks so much for the nice introduction. We certainly appreciate the opportunity to talk with everybody today. I would note that those of you who are like, hey, I've seen him speak before and he usually wears a tie, or isn't he attorney, why he's in a suit? Frankly, with everything that needs to be accomplished in the next 29 days, we're just going straight casual attire at this point. So I don't even have time to cut my hair, frankly. So a number of changes have come up. We're going to focus on the big ones today, and certainly those that are coming up for the new year. So let's get started. You may see the first slide of 2019-2020 legislation. What are you? We're in 2020, Michael. Why are you worried about 2019? Well, we're going to get to the Equal Pay Act in a little bit, and the Equal Pay Act did come in, or was at least, passed in May of 2019, signed in June of 2019 by the governor. So that's why we may be hearkening back to all those times ago. Colorado's new sick leave law, which is a law which technically isn't in place until January 1, 2021, but don't let anyone convince you of that. It is in place now, and we are under obligations to comply with it. It is known as the Healthy Families and Workplaces. It starts, as I said, on January 1, 2021 for those with 16 or more employees. Other employees can start on January 1, 2022. Initially, I mean, it was passed during a very short legislative session, and it was passed certainly in response to everything that's been going on since who knows how long, but at least since spring, if not maybe into 2019, with respect to coronavirus COVID. And what the state legislature realized is perhaps the employers did not have a lot of sick leave out there for employees to use during such times. And of course you may say, well, why then is the state of Colorado worried? Well, they're worried because what happened is everyone started applying for unemployment benefits, and the state of Colorado was probably not aware that so many millions, so many hundreds of thousands, tens of thousands, I forget the final number, in the state were going to apply, and that's one of the reasons why this came in. So it is a leave that provides for employees to have leave for really, as identified here, their own mental or physical illness. As you'll see, these are very broad reasons. Caring for a sick family member, then they're entitled to leave to care for that family member. An employee is a victim of domestic violence, harassment, or sexual abuse, or need to assist family members who are victims of that. And you may say, well, what is a domestic violence leave doing in a sick leave? Well, what they did is they actually put healthy families into basically the domestic violence leave section and just put it all in. So we are now under that as well. And where an instance where a public health official has ordered the closure of an employee's place of business. What must we provide? Well, this is the key part, and this is where it gets a little tricky. We are required to provide as employers, those with 16 or more, right at January 1, those with 15 or less, January 1, 2022. We are required to provide 1 hour of paid sick leave for every 30 hours worked. So employees must accrue 1 hour of paid sick leave for every 30 hours worked. up to, you can set the maximum, this is weird to say, but you can set the maximum at a minimum amount of 48 hours. By that, I mean, you can set the maximum at 48 hours that they can accrue. You can set it at 84, 480, 840, whatever you want, but it can't be any lower than 48. You can't do 32 or 30. And the law permits the employee to roll over up to 48 hours. Really, that second sentence perhaps should have been in another bullet, but really all that's saying is you don't have to do it on an accrual system. You can do it on a, here's 48 hours, employee. Here you go. One of the things to keep in mind throughout as we go through all of this, because it's one of the things a lot of employers have really hooked onto in reading this, is that the law permits you to, and I'm going to use a technical legal term here, mush your policies together or double dip your paid leave with what is, with this requirement, with what you're already giving. So for example, if you already give employees, if you allow them to accrue 1 hour of paid leave for every 30 hours work, well, great, or maybe a higher amount, great. You met the requirement of the accrual, but that doesn't end the requirements, because you have to make sure as part of that, that you're giving the employee every right that the law provides. So for example, your PTO policy may not have those things we discussed previously, leaves for sick leave or all that, or domestic violence, but you have to change your, so you have to change your policy to make sure that's covered. Additionally, you may say, well, we have a waiting time. We give PTO, we give vacation, but we don't give it till they've been with us for 90 days or 1 year or whatever. Under Healthy Families, the name of the law, employees have to start accruing on their first day of employment, or they have to start building up their 1 hour for every 30 hours worked. So, and you may say, well, we don't give vacation leave to part-time or casual or temporary or PRN or per diem or whatever. You have to, under Healthy Families, every employee gets this leave. So before, a lot of employers, I think when I say you can mush these two together, they think, sweet, we've already got it covered. Keep in mind, there's a whole bunch of things you may have to change. For example, your accrual amount. For example, when they can accrue, how they can use it, when they can use it. All that may change under Healthy Families. In addition, as we'll see in a second, Healthy Families requires employers to provide employees notice of retaliation rights, how they can sue the organization, how they can file a claim against the organization. Most of us don't have that in our vacation policies. That's something we may have in an FMLA policy, but not in a vacation policy. So for that reason, keep in mind before you just think, I've already given enough, there's a lot more your policy has to identify. Another example of it is, what do you do when the employee terminates? Do you give the employee the entire amount, which would now include things they've accrued for Healthy Families, because Healthy Families doesn't require you to pay that amount upon termination. But if you drop it into your PTO, well, then you have to give that upon termination. So keep in mind before you just think, oh, I already gave, oh, I've got a paid leave. It's got to meet all these requirements. Oh, what else? Oh, we can require the employee to use the paid sick leave in hourly increments. You can even do smaller increments if you'd like. This is a big change in the statute, or a big change for many of our day-to-day, which is a lot of us have a policy that says, hey, employee, if you're sick, we're going to make you get a medical certification. Well, the law now is, if it's for a leave under Healthy Families, and frankly, I can't imagine an employee missing for an illness or an injury or anything that isn't covered by Healthy Families, but I guess it's possible. We cannot ask for the certification until the employee uses 4 or more days. I think that's an interesting number. 4 or more days, because when you cap the leave at 48 hours and the employee has to miss 3 days before you can even require it, well, that's 36 of the 48. It's not, doesn't give us a lot of time to get that certification. Or if the employee takes it, a day here, a day there, 2 days here, an hour here, they may never get that 4 or more days, work days consecutive to even allow the organization to get a certification. So be very careful requesting that certification prior to that time period. As I mentioned, you don't have to pay out unused sick leave upon termination. The act also, so there's 2 components to healthy families. There's one component, which is in essence the sick leave component, which is the 1 hour accrued for every 30 hours worked. There's a second component to healthy families, and that is the bucket drop of 80 hours into someone's bank if they don't have that much time, if a public health emergency is declared. So if the governor declares a public health emergency, if your county, your city declares a public health emergency, we as employers have to drop in 80 hours of leave into the employee's bucket. This works a lot like, remember, Colorado Help from May of 2020, when we had those 4 days, but if the employee, we had to give 4 days for leave, but if the employee didn't have 4 days, we had to drop it in. And if the employee did have 4 days, we could say, you already got it. This works that same way. If they've got 80 hours, well, then we don't have to worry about it. But if they don't, well, then we have to. One of the weird things about healthy families is while you can cap 48 hours, the leave of 48 hours or higher, you're still only required to provide the employees that they can use the leave for 48 hours a year. Let me give you an example of that, which is, let's say my organization, which actually is under 16 employees, but let's pretend for purposes of this example that my organization is going to start complying with healthy families on January 1. Takes me about 5-6 months to accrue my 48 hours. And at that time, something happens and I need to use all 48 hours. So I use the leave up by August 1. I have exhausted all my 48 hours and used all my 48 hours. And I start to accrue on August 1. I accrue an hour here, an hour there, an hour here. And come November, I got, let's say, 10 hours in the bank, 15 hours in the bank. I come back to the organization and I say, hey, I want to use those accrued hours. An organization can say, no, yet, 9. You don't get to use those because you already used 48 hours. So keep that in mind as a provision of the cap, but you also got the issue with the 80 hours if there's a public health emergency. So it's really, that's one of the weird things. I mean, I certainly understand and cognizant, this is a small organization, we only have 7 employees. So just suddenly giving everybody 48 hours is quite a financial burden. But when you combine the policies with PTO, it can make it really wonky, another legal term, particularly with trying to keep track of the 48 under the sick, keep track of the 80 if there's a public health emergency, keep track of when they use it for vacation. It can be done, but it's a very difficult policy to kind of make sure it works with all your other policies. With respect to this 80 hours of if there's a public health emergency, keep in mind, well, one of the provisions says that even after the public emergency is over, the employee can use those hours for up to 4 weeks after the public emergency ends. So if the governor declares a public emergency for all of January 2021, it goes away February 1, 2021. That your employee could still use that 80 for the reasons identified for the entire month of February, even though the leave and even though the emergency notice and even though the public health emergency ended on January 31st, 2021. So keep that in mind. It's an additional 4 weeks beyond the leave. What are the reasons for the leave under this? Recognize many of these: self-isolating due to a positive diagnosis, suffering from pre-existing conditions that would make employees more susceptible to serious harm. A lot of the questions we've been having as this year has played out, where the public health official or the employer have deemed it to be unsafe. That's an expansion of the current leaves available because it allows us to declare something unsafe. They get it for that reason. Just a whole bunch of other leaves available should there be a public health emergency declared. One other thing, under the 80 hours, remember we have two reasons for leave under healthy families, one the 1 for 30 and one the 80 hours bucket drop. This, we can request medical certification. This 1 for 30, we can request medical certification after 4 more days. The emergency leave over here, the 80 hours, we cannot request certification. So from that standpoint, there's little we can do as an organization. We can ask the employee why they're missing, but we can't ask for any certification because of it. One big thing that I read the act to say is that we have to provide employees with notice. And so in doing that, the place I've been putting that, recommending it, is in the employee handbook, and display the poster from the division. There's the link right there. So if anybody wants the poster, you can certainly go get it. And they've talked about updating the poster as well. The notice has to specify the amount to which the employees are entitled. They also have to identify, the basis for leave. You gotta do that in your policy. So here's one of those switches I mentioned. Most of our vacation and PTOs don't have a retaliation provision, but this one does. You have to notify the employees that the organization cannot retaliate against the employee for requesting or using paid sick leave, and that the employee has a right to file a complaint or bring a civil action if the paid sick leave is denied. Now, if you mush those two together, the question becomes, well, does that mean they now get to sue you for violation of the vacation leave? Whew. We'll find that out, won't we? So that is a big requirement under healthy families. It's 2 leaves. Only one is due for a public emergency. One's due to a public emergency, so we don't have to worry about that one until there actually is a public emergency. The other one is the 1 for 30. Make sure that all employees are accruing under it. Newer, long-term, part-time, full-time, CAL, whatever employees they may be, they are accruing. Not independent contractors, have to be employees, but everybody who's an employee gets to accrue. That's really what the law went into great detail about healthy families. What all the publications went into healthy family. The next thing, which I'm going to go over kind of quickly, because we only have it for 29 days. And so those of you who may be watching this video after the 29 days, you may say, well, why did he do all that? Because it's no longer applicable. But one of the minor, I shouldn't say minor, one of the major provisions which didn't take up a lot of room under healthy families is the requirement that we are all currently covered by the Family First Coronavirus Response Act, which is the act the federal government put in place back in April, which provides an employee 80 hours of leave if the employee is missing one of 5 reasons. Some of you may say, no, I think it's 6. Well, it's 5 under the law, it's 6 under the regulations. Unfortunately, I memorized it when it was 5, so I'm sticking with 5. But they're the same reason. There's not a new reason in the regulations. They just renumbered them. In the law, and you can see how the conversation went under healthy families, which is, the legislatures, representatives were sitting around talking, and they said, well, this is great. We're giving everybody leave January 1, perfect. And someone probably went, well, hold it. What's happening until January 1? And someone probably said, well, we should just make everybody comply with FFCRA. And everybody went, what a great idea. And that's what they did. So every employer is covered. Now, I know some of you with more than 500 employees or less than 50 employees who don't have the financial wherewithal, which is most of us with under 50 employees, to offer this leave, or those who are in the healthcare industry. I hear from them both all the time, like, well, hold it, we're exempted under FFCRA. You are healthcare industry. You are employer with less than 50 employees, and you are employer with more than 500 employees. You are completely exempted. Sorry, as they say, when you're a mom, you call it a bad time. So let me just keep that in. When you have, so you got those three employers were specifically exempted, or three types of employers were specifically exempted from healthy families. And you remain exempted from healthy families. But you also are covered by, you remain exempted from Family First Coronavirus Response Act. You are covered by healthy families. Ignore that last part. So you are covered by healthy families and workplaces if you have 16 or more employees starting in January 1, less than that, January 1, 2022. But as of right now, we're all covered by Family First Coronavirus Response Act. And we're covered by that because Healthy Families said organizations, no matter what size, have to comply with the Family First Coronavirus Response Act. That means everyone who thought they were off the hook, you were not off the hook. So this went into effect July 16th of 2020. So if you haven't been doing that, and for example, you've been making your employees use PTO for reasons that are covered by Family First Coronavirus Response Act, you should probably look in going back into recrediting the PTO and calling it under Family First Coronavirus Response Act. Because the Healthy Families did say that every Colorado employer had to comply with Family First Coronavirus Response Act from July 16th, 2020 through December 31st, 2020. Government, and you're listening to this, you're off the hook. What are the 5 reasons? Well, I'm going to go through these really quickly. As I mentioned, it's up to 80 hours. It's prorated for those who are part-time. If an employee, reason number 1, if an employee is subject to a federal, state, or local quarantine, or is told by a healthcare provider that they should self-quarantine, they get 80 hours of leave, a lot of these, at 100%, capped at $511 per day. Don't ask me where they came up with that, and $5,100 and $5,110 total. If they're subject to a quarantine, they have to get that leave. Or if they they're told they should quarantine. So for example, you get a note from your employee's doctor, hey, your employee's wife just tested positive for COVID. We think the employee should quarantine. The employee hasn't shown symptoms and the employee hasn't tested positive yet, but we still think the employee should quarantine. That employee eligible for leave under the Healthy Families requirement to comply with Families First. I go in here into what quarantine orders, stay at home, which is our order from back in April. Definitely met the quarantine order, unless you're critical business. Safer at home probably did not meet the quarantine order, which is what we're under now. Was it December 2nd? So who knows when that will change. And of course, your county, town, city, or other locale may vary. The leave can be used only if the employee subject to the quarantine order is prevented from working or would have been able to work had it not been for the order. So for example, if you have a retail store and the cashier is told they have to quarantine because you're shut down the whole store, that person is subject to a quarantine order, they may not be eligible for this leave because they aren't going to work anyway. So keep in mind that they have to be able to work. I think I covered most of these things. Okay, that's reason number 1. As I say, these are only in effect for 29 more days, so I'm kind of going to go through them quickly. If the employee is experiencing COVID symptoms, so they're experiencing COVID symptoms and they're seeking a medical diagnosis, they have to meet both. Have symptoms, experiencing getting a diagnosis. If they're just symptoms, well, we'll talk about that. in a little bit. Or if if they're getting a test, but they don't have symptoms. Again, if they don't have symptoms, they have to have symptoms and seek a medical diagnosis. If they are, then they would get the leave here. So for example, if I start experiencing symptoms on Monday, I go to get a test on Monday. On Friday, I find out I'm negative, but I still have symptoms. I wouldn't fall under this because I'm not seeking a medical diagnosis anymore. Now, maybe as part of my notice, and I was told by my physician, you should stay home in quarantine, even though you're negative. Now I'm under number 1. But in the interim, I'm not under number 2 because I've gotten my medical diagnosis, something to keep in mind there. Number 3, if you have an employee who's caring for another who has been told to stay home or is seeking treatment or medical certification for COVID and is experiencing symptoms. So number 3 is if the employee is taking care of a family member who is under number 1 or number 2. Those are mine. Number 4 is the child care issue. If you have an employee who's missing because they need to take care of their child due to the fact that that child's school is closed or the child's daycare is closed, you would get leave. It's a lower amount. You see, it's only at the 2/3, $2,000 total, but it is still for the 80 hours. Those are all the child care. By far, the one that has drawn well, that is a good argument, is number 5. Number 5 is a similar health condition. And it states on the slide, it is a little streamline of the entire statement, but if the employee is experiencing any other substantially similar condition as specified by the Secretary of Health and Human Services, and the addition is in conjunction with the Department of Labor, which they have identified, those two, Secretary of Health, Department of Labor, has said is just like COVID. When you read this, at least I've never seen any pronouncement. I've never seen the Secretary of Health get up and say, here's what we think, and working with the Department of Labor are symptoms similar to COVID. I haven't seen that pronouncement. I haven't seen the Secretary of Health issue anything that says specifically that. So a lot of people are opining, well, then we don't have to worry about number 5. And that's a pretty good argument. My only concern is that if you go to the Health and Human Services website, click on their COVID page about this far down, if you can see me in the video, on the left-hand side, there is a little link that says COVID symptoms, and it takes you to the CDC website. I don't know how those got up there. Was it based upon the Secretary of Health and Human Services working with the Department of Labor? I certainly didn't see anything to that. So it's become this issue as to, is that leave really available to employees, since the Secretary has, at least to my knowledge, and many's knowledge, has not worked with the Department of Labor. So interesting thing to keep in mind there. For those who are watching this before the end of December 2020, I have a feeling you're going to get a lot of requests from employees the last X number of days here saying, oh shoot, I'm about to run out of leave. I should use my leave. And there's very little requirements or very little rights we have as employer to demand certification under the FFCRA. We don't have the ability to tell the employee, go get a certification, because when the federal government set up the FFCRA, they wanted physicians focusing on taking care of people, not writing prescriptions, not writing certifications. So it specifically, we don't have that requirement, or we don't have that right to demand that the individual get a certification. Now, you can make sure, you can tell the individual, you have to tell me which of these 5 reasons you're going out for, because frankly, that's the only way we can pay. But you can't condition leave on that. And we talk here about how the 5 things under the leave, employees are entitled to 80 hours, part-time employees get an average of 6 months or less. Yes, that is the 3 components of healthy families, which is healthy families 1 hour accrued for every 30 hours worked, healthy families 2, which is they drop the 80 hours if there's a public health emergency, and 3, Healthy Families requires us to comply with the FFCRA, which came out in April. Colorado Proposition 118, I'm not going to cover this much because frankly, I've been joking with folks. This just got passed all of about, now a month ago. And by the way, I won a lot of lunch bets on this with people who told me it wasn't going to pass. And I always said, I think it's going to pass because if you're asked, if most people are asked the question of, do you want more paid leave? Who says no to that? Or even if you're asked, hey, do you want more paid leave? It'll cost you about $1,000 or so for the paid leave during the year. But if you pay that, you'll get 12 weeks of partial paid leave. Who says no to that? Well, 60% of Coloradoans said yes to that. So we have Colorado Proposition 118, which is paid FMLA. We are not taking, this is not applicable for a number of years. We don't have to take premiums under it until January 2023. Nobody gets leave under it until January 2024. So we got tons of time to either be smarter then or win the lotto. I'm banking on number 2. So I'm playing the lotto like crazy because this just looks like a lot of work when it comes up. But you can see it's basically going to work like the FMLA, but it's going to be paid. Just as a little sidelight, I at least what I've seen is the Colorado has said, don't worry. Well, where did this come from? It came from the fact that our legislature tried for 2 years to get this passed, wasn't able to, so they just turned it over to the voters. They claim that, by they being the Department Colorado, says, don't worry, we have the money to pay for this. It will not go up over 1% premiums from employers and employees, as long as no more than about 3 to 3.5% of the employees use the leave. So great, as long as no more than 3% of the employees use the leave, we will still have money. I'm also taking bets on whether or not more than 3% of employees use this leave when it's being drawn from most of our paychecks. Just a thought, but we'll leave that for another day. So that's Proposition 118. The last, one of the last big changes, I think I have it. Well, we'll see. Don't forget that the Equal Pay Act kicks into effect January 1, 2021. Doesn't seem like everything is. Yes, it does. January 1, 2021, Equal Pay Act becomes effective. By far, the #1 question I'm getting on the act these days is, any chance the governor pushes this off because we're dealing with COVID? Sure, I guess it's a possibility. I haven't seen anything on that. It's been passed since May of 2019. I don't think the governor is going to give us all a reprieve. So I think it's coming in January 1, 2021. For the most part, that shouldn't be too much for employers because at its core, the law requires what's been required since 1964, that employers cannot discriminate on the basis of sex for compensation. That remains the law. The real key with this is how to handle day-to-day issues. As we say here, basically everybody's covered. When we talk about wages, we're talking about all benefits, so bonuses, every other compensation is going to be looked at when we compare. What are the requirements? We can't pay an employee of one sex a wage rate less than the rate paid to an employee of a different sex. Sex is defined also as sexual orientation as well, so keep that in mind when you're looking through all these things. For substantially similar work, regardless of job title, based upon composite skill and effort and responsibility. Where does the analysis start from? Job descriptions, job descriptions, job descriptions. Your job descriptions have to be dead on, spot on, accurate, no questions asked. Just simply saying, well, the reason why you can't compare Michael and Alicia's wages is because Alicia does all these different things and Michael does all these different things. That's not what their job description shows. So you want your job description to evidence what the actual position is performing. The big change in this law is that it limits our defenses as organizations. We used to be able to say, well, the reason why Michael and Alicia are paid differently is because of this reason, that reason. We could pick whatever reason worked. Now we're limited to 6. If it's not one of the 6, it don't matter. So Alicia negotiated better than Michael when she came in. That's why she gets paid more. That's not one of the 6. It's got to be in one of the 6. And or one or more of the 6, you can use up to all 6 reasons. So I recommend employers put in their job description which of the factors they are using. Here are the factors we're going to go through quickly because most of you heard me talk on this maybe. Seniority system, merit system that measures earnings by quantity or quality of production, geographic location. You got employees in Durango, got employees in Denver. You can pay them differently based upon geographic, but you want to make sure your job description identifies geography. Education, training, or experience. This tends to matter most when people are coming into the job, not when they've been there a while. And then finally, travel, if travel is a necessary part of the work. So those are your 6. If it's not one of the 6, well, it's got to be. You've got to focus on those 6 reasons as being the reason for the pay differences. The big change in the law. Then each factor is applied reasonably. So for example, you can't say, well, travel matters if travel really doesn't matter. You can't say geography matters if what you're comparing is people on the 2nd floor versus the people on the 1st floor. That's not a geographic distinction. You maybe could say, well, the people on the 1st floor perform different duties than the people on the 2nd floor. That's fine because they're in a different job description, apples and oranges. That each factor counts for the entire wage difference, so it's got to be the entire wage difference. Keep in mind that this law does, in my opinion, and there may be another group that disagrees with me, does not require calculation, does not require X amount of percentages and X amount of this and standard deviation of that and regressions analysis. It requires explanation, in my opinion. So for example, Alicia makes $30 an hour and I make $20 an hour, and the organization says, well, Alicia's been with the organization longer. She went to Notre Dame. That's a better school than Michigan State. No, it's not. Because I went to Michigan State. If we say, hey, Alicia has to travel more because she's more in Denver, so she's going back and forth more than Michael. If we say, hey, Denver's got a different cost of living than Grand Junction, so that's why we pay Alicia more. That's an explanation. Do we have to come down to the penny and say this is exactly why the differences are? I don't read the laws requiring that. Of course, we will see cases coming up, but initially, that's not the way I read it. Don't use prior wage history. Don't have it in your applications. Don't have it in interviews. Don't even mention it. You got to get supervisors prepped for this. It's very important. So for example, if someone is asked, well, Michael, how much do you want in this job that you're applying for? Well, in my current job, I make $20 an hour. That's a problem because now we've just heard what Michael got in his previous job. So you want to be ready to say things like, whoa, we don't need to know how you're coming up with the number for what you want to earn. We just want to know what you want. Don't ask applicants, how much vacation leave do you get over at XYZ Inc.? Doesn't matter. What are the health benefits like at your current employer? Can't use them. Keep those questions out of the interview. And if someone starts to bring it up, you want to make sure you shut that down. You can't use it. And it is all over the place in the law. So what do we need to do? Well, we need to start thinking about maybe creating a seniority system, a merit system, systems that measures quantity of production, geographic distinctions, each of those things. They're not really all defined under the law, but I see that as an opportunity for us to be a little aggressive on this. Okay. Yes, we went over this. There's a bunch of times it was mentioned in the law about don't use past information. And don't, of course, discharge or discipline someone who wants to. The other big thing is posting. that organizations have to post all opportunities for promotion to all current employees on the same calendar day and prior to making a decision. My watch is telling me, Stan, you're not going to make your Stan goal. I'm not going to stand. So you have to post all positions. In addition, internally, you don't have to post externally. But hold that thought for a second. You have to post the compensation rate or range, whatever you're going to do, general description of benefits. We give vacation, we give insurance, and all those kind of things. You have to post that for all positions. And if you post externally, you don't have to post externally, but if you do post externally, you have to have that same information in there. So if you use Craigslist, if you use Glassdoor, Glassdoor, whatever the glasses are, you have to post those as well to make sure that's in there, with 3 exceptions. And frankly, I am so disappointed I didn't realize the first exception, because I would have been making fun of this for pretty much the last year and a half, which is there is an exception if you have an employee currently performing the position that you're thinking of getting rid of. So for example, if Michael Santo and Severn is thinking of getting rid of me, and on some days I would welcome that, but not sure I really love what I do. If they're thinking of getting rid of me, it would seem a little odd if on our poster board back there it says, hey, we're hiring for a partner. I'd be like, we are? Are one of our partners going somewhere? So if you're hiring for an administrative assistant because you're going to be pushing your current one out the door, you don't have to post that position because of the confidentiality of it. These regs just came out about 10 days ago, so make sure you check. The other one is for a temporary position, and the other one is, the third one is, if you have a promotion ascension in mind with respect to that individual that will take less than a year, you don't need to post that next job. So for example, you hire for a direct support professional, hire the person without a CPR, and you tell that person, hey, we'll move you into a DSP2, direct support professional 2 position when you get your CPR certification, but you have to get it within the next year. If the employee then gets that CPR, you don't need to post before you move that person into the DSP2. It's in the regs. Frankly, I want to do a full talk on all the holes created by the regs, because there's a lot of things, but I'm not going to spend on that. Just make sure you take a look, because there are 3 pretty big exceptions, which will make it interesting. One of the things we're required to do is keep track of job descriptions. We have to have job descriptions. We have to have the wage history for each employee for more than 2 years. Oh, it's not actually 2 slides, it's a couple more, but there's a 2-year statute of limitations and all those kind of things. And then Diana may ask, hey, Michael, do you recommend organizations take a look at their pay practices? Not only do I recommend that, it is in essence mandated by the law. And that is, unless the employee, if the employee sues, let's say they prove $10,000 of damages because they didn't get paid as much as someone in a different sex, they get $10,000 plus they may get an additional $10,000, which we refer to as liquidated damages, unless the employer can show they acted in good faith. How does an employer show that they acted in good faith? Well, they do a comprehensive wage audit of its workforce. Its workforce group who keeps looking at external, I'm not going to mention the group, but who keeps looking at external employers. You do not have to look at external work employers. You do not have to look at a wage analysis for the state. You don't have to say, wow, our administrative assistants are paid less than others in other organizations. Doesn't matter. That's irrelevant. The only thing that matters is how are they paid compared to those within your organization. You don't have to compare to other organizations. And so, but you do have to do that. And how do you do that? Well, you basically get, let's say you got 5 administrative assistants. You want to list them all, list their gender, list their pay, list the factors that you're going to use to make compensation, seniority, merit, who knows what else. And then you want to analyze how people are paid with respect to that. So that's where the analysis comes. You're supposed to do it once every 2 years. I recommend once every year, and I recommend you definitely do it before January 1, 2021, so you know if you have any potential liability problems. So make sure you're doing that analysis of your entire workforce. You may say, well, I've got, our workforce is all male, or all of our flux capacitor repair people are all male, or all of this position are all female. No reason to do it. Yeah, I think there still is before. I mean, you may not have liability situations now or concerns, but there may be internal pay equity problems you want to make sure you address. Additionally, if you do end up hiring someone from a different gender or a different sexual orientation than the current group, you're going to want to make sure that those wages are all set up before the new person starts. So I recommend going through your entire workforce right now. I had a question come up the other day where someone says, hey, our vice president of human resources is way out of whack. We're going to have to make a big change. And I said, based on what? And they said, the law. And I said, well, what are you basing it on? They said, well, one, they're paid substantially less than everybody else in the area. And I said, that doesn't matter. And it may matter to the HR director, and maybe you want to be nice to the HR director and pay them as much of other places, but the law doesn't require that. And they said, well, number two, they're vice president, and the vice president of HR makes less than all the other vice presidents of marketing, of finance, of other places. And I said, but why are you comparing vice presidents of different positions? Vice president of finance does different things than vice president of HR or vice president of marketing. That's an apples to oranges comparison. You only really need to address the individual's positions. Now, if it turns out the vice president of HR does the same thing as the vice president of marketing, because that's what the job description shows, that would be a concern. But in the interim, don't forget, you don't have to comply with, you're not looking externally, and you're really only considering position by position by position. You want to be careful in doing these analyses. I've seen a lot of organizations create grades. We got a flux capacitor 1 and a flux capacitor 2 and one flux capacitor 3. Well, what do? Well, they pretty much all do the same thing. Okay, that's not good, because then we really do need to compare all those positions. So you want to make sure that it is addressed that way. Well, I've got some sample language here that you can use for your employee handbook on the EPA issue, just something to consider. Final two small little points, and then I think Diane's got some questions. There are 2 new posters out that you gotta have to post. I've been putting them in employee handbooks. You don't have to. You can put it into your poster board, but these are 2. The second one we've seen before. The first one is a new one. Really just came out a couple of weeks ago, and it concerns misclassification of employees as independent contractors and employees' rights to file unemployment benefits. That's in this poster on the screen. Make sure you're posting it or including it in your handbook. It's a requirement now to post that. And of course, comps poster 36, that is 37 is soon to be released, but right now it's 36. That has to be signed off. I would put it in your employee handbook as well. Yes, you have to do that. So those are the big new requirements. You got the healthy families and workplaces, which creates the 3 leaves during the next, 1 leave now, reinforces the 1 leave now to the end of the year, that creates 2 new leaves on January 1. Then you've got Equal Pay Act, and then you've got, well, that's number 2 actually. Then you've got the issues with the posters that just came out. So make sure you're hitting all those.
Thank you, Michael. I do have one question, and it's kind of a practical question as it relates to getting in compliance. But what would you recommend as kind of the process of kind of getting an employee leveling out the field, I guess. So if you have someone who you've been, whether it be you're claiming them as non-exempt and they need to be exempt, or that they're non-exempt and they're exempt and now need to be non-exempt, or whether they have a wage disparity, what do you recommend as like a practical way for people to approach that, document it, and kind of develop a path forward?
That's a really good question. Like, okay, we've just realized we pay Alice way more than we should because Bob makes way less, and they do the same job, and we haven't been able to explain what the pay difference is. So we've got to, and we don't have the money to raise Bob. So we're going to meet them in the middle. We're going to just move Alice down. What do? You want to, the key is really document. It doesn't have to be in any certain particular fashion. It may just be as simple as an email. I would certainly recommend having a conversation with the individual, explaining the change. I don't think you need to go into detail in terms of like, well, here's what the Equal Pay Act analysis says. I don't think that needs to happen, but you definitely want to get an employee an understanding of, hey, due to some changing laws, we need to make changes. Now, is that comps, which went into effect in March 2020 and concerned exemption issues? Is that, don't forget, oh, by the way, 2021, don't forget that, I was just looking at my sticky because I got one on the board. 2021, the salary basis test goes up to 40,500
right.
under the if you want somebody to be exempt, they have to be paid at least 40,500. Then it's going to go up next year too. So every year for about 4 years. Maybe now they need to be changed to non-exempt because you're not going to pay that. I would recommend having a conversation, but then just simply following up with an email. It doesn't have to be, hey, Michael, as we talked about, this is me typing. Hey, Michael, as we talked about, we'll move you from a salary amount of $38,000 down to $19,000 a year. I would focus when you move someone from exempt to non-exempt about, hey, now you've got the chance to perhaps earn overtime. So you may end up actually earning more, but I can't classify you as exempt because you don't meet that salary threshold. So make sure you want to, I think, to Diana's question, you want to have that discussion with the person, but you then just follow them with an email. You are, as an organization, allowed to move your employees' wages. That still remains your right. So from that standpoint, don't hesitate to do that.
Thanks, Michael. That's really helpful. Well,
Sure.
You've done a great job at kind of covering all the topics here, and we really appreciate your time and support. Yeah, good job.